everyone. Thank you for joining another Casework stream. So excited to have Kelsey Stokes with us. Kelsey, it's been a while. I guess the last time we had a stream, it's been a couple years, but was excited that I had an opportunity to see you in person at the Women's and Legal Leadership reception there at Mass Tort Made Perfect a year or so ago. So anyway, thank you so much for taking time to connect with us today. And for those of you, I don't know if there's many that don't know who Kelsey is, but just in case you just graduated from law school and you're starting out, Kelsey is an attorney in Houston at the respected firm. It's called Fleming, Nolan, and Jez. Kelsey is a recognized national leader in the hernia mesh litigation. So much so in 2018, she was appointed as the co-lead counsel for the Plaintiff Steering Committee for BARD. And then in 2022, you were appointed as the co-lead counsel for the Covidian MDL in Boston. I know you've been busy at the state court level over the last 5 years, serving as the co-lead for the 3 Ethicon, New Jersey MCLs in front of Judge Porto. So thank you, Kelsey, for being here with us today.
Thanks for having me, Susan. Good to see you again.
Yeah. I know a lot has happened since we last connected in November 2021 when we did the stream on hernia mesh litigation. So I'm excited to talk about all the updates, but really interested to hear from you about what's happened since then. Will you share with us the defendants that are left, the products, and for those that may not be as familiar, just some of the claims in this case?
Sure, absolutely. So I think one of the most common questions I get is, given the maturity of the hernia mesh tort, is there still room? What is there still viability to hernia mesh cases? And my answer is simple: absolutely. The defendants that are left are the 2 biggest defendants. The biggest defendant by far, as I said at the last time we met, is BARD. BARD has, at this point, it's probably well over 65% of the market share. They make over 20 devices that are all being implanted today. And there has not been a removal from the market, and that's largely BARD's decision. And so people continue to get implanted with these meshes made by BARD, and also continue to be injured. And so these constant revision surgeries that are coming, that by far BARD is definitely still a viable case. The other manufacturer that is left is Covidian. Covidian, whose parent company is Medtronic, that was recently in 2022, summer of 2022, MDL'd in the District of Massachusetts in front of Judge Saris in Boston. And just like BARD, Covidian makes a substantial number of products, about over 20. And just like BARD, those products are still being implanted as we speak. And just like BARD, those products are still injuring people. And so as long as those products continue to injure people, and as long as they, by they, I mean the 2 defendants that I believe are really the most viable defendants still remaining, have not come to the table for any meaningful resolution, we're going to continue to prosecute these cases against these defendants. And this is very much a viable tort. I would say that the defendants that remain, which would be BARD and Covidian, make up over 80% of the market share. And again, between the 2 of them, over 40 products are being implanted and injuring patients daily.
Well, I'm so glad you said that, because attorneys ask me all the time that are interested in getting into mass tort. They always say, do you think there's any hernia mesh cases still to get? But if they're still out there manufacturing the same products, having the same injuries, you just said, we heard from you that yes, absolutely, there's still cases to obtain and work up. And we know, yeah, go ahead.
And what I want to point out as well is that these products, because of the nature of these inflammatory polymers that these products are made of, they're not acute injuries. In other words, they don't manifest immediately. This inflammatory, I talked about it on our last interview, and I hope that everybody watches that. Is that the nature of these polymers is that it's a chronic inflammatory stimulus that does not go away until it's removed from the body. And depending on the patient, that could be years. And so many people who were implanted maybe in 2016, even before that, maybe 2012, they might have been fortunate enough to have the latency that's maybe some patients didn't. But as I said in the last interview, these products are like a ticking time bomb. And so unfortunately, the injuries will manifest. It's just a matter of when. So absolutely, even if a patient had a product implanted back in 2012, there could still be very viable, very, very serious injuries in a viable case.
Yeah. Well, I know that, we were talking and prior to recording, BARD grew, the MDL grew by 23% in 2022. So what do you attribute this substantial growth to in claims?
I think, again, this is a manufacturer, which is the largest market share of hernia mesh devices made of a highly problematic polymer in polypropylene, and it's being implanted every day, unfortunately. And the surgeons are unaware of the dangers that these products present. And so, as I said, it's not an acute process. This is a process that happens over time. I think the growth in the MDL is a result of and illustrative of how problematic these products are. The patients are going to continue to be injured, and as long as patients are injured by these products, I know that we are going to protect these people and file cases.
Yeah. Well, let's talk a little bit about some of the Bellwether trials. I know it's been a roller coaster so far. In the first Bellwether in July of 2021, so approaching a couple years ago, the jury ruled in favor of BARD. So how did that outcome shape the litigation strategy going forward?
Well, so that's a good question. The product that was at issue in that first Bellwether case was the Ventrolite ST. And that is the ST stands for separate technology, which is the coating that is placed on top of this plastic polymer to be placed right up against the valve, which, if it doesn't work, causes significant injuries. As if you and it's all there in the paper, in the filings, and in the daily transcripts, you'll see that product, any product that has an ST coating, is very problematic. We put Tim O'Brien and I, along with our great trial team, our great plaintiff steering committee, put together a phenomenal trial package for the ST line of products. Of course, we can always learn from any trial, but really, I think the lesson from that trial is more of a case-specific issue. That verdict was a result of very case-specific facts. And one thing that I know that this broadcast will go out to not only attorneys, but also people that have hernia mesh devices in their body. I think that the lesson of that first trial, as a reminder, this plaintiff, he did have significant pain. He had a lot of pain. In fact, every morning on the way to the courthouse, he would grab his abdomen in pain. The problem is that he didn't go to the doctor. And a lot of these, I talked to so many plaintiffs who are just so disillusioned and, frankly afraid of additional surgeries, that they don't necessarily want to go to the doctor because they just don't, these hernia mesh products have hurt them so bad, they don't want a repeat incident. And so this gentleman did not go to the doctor. And so even though I know he was in pain, the jury didn't see that. There was no evidence in the record where this man had gone to a doctor and addressed his problems with pain. And so while I understand the fear of additional treatment, I think the message is, look, if you're in pain, at least go look at your treatment options and talk to doctors. Obviously your decision needs to be a decision based upon the risks and the benefits after talking to a doctor. But, really the lack of any sort of medical documents that show that this man was in pain is the reason why that trial was lost. So that was the takeaway, if I had the biggest takeaway from that case.
Yeah, like you said, the outcome could have been the same, but at least you would have the documentation to substantiate, the claim that you're stating of the pain. So yeah, that makes sense.
And as I said in our last interview, we did have a little bit of feedback from that jury, but we also had the question that they asked, which was, well, we want, in order to say yes to the general liability of the company, do all of the elements have to be yes? And that final element of, and he was injured, also had to be yes. And so because that was not a yes, in my humble opinion, that is the reason why that was a defense verdict.
Got it. Well, tell us a little bit about the second Bellwether trial, and what do you think was like the reasoning behind the low jury verdict for payout?
So the second Bellwether trial, what I think, to me, I'm very proud of that trial, by the way. This is a product. This is the Ventralex product made by Bard that's been on the market for decades. And we actually had a jury, a unanimous jury, say that a product that is still on the market was defective in its design. And that is a really big deal. That a product still on the market, a jury, again, this is federal court, so we have to be unanimous here, said that this product was defective, and we won on design defect. The verdict, I think the verdict is, as far as the value goes, of course, do we want verdicts that are, obviously as a plaintiff's lawyer, you want the biggest verdict that you can get. I think that, and we did not get very much feedback from this jury, so this is all just me speculating. I simply think that we had maybe one juror that was a little bit more recalcitrant than the others, and so when that happens, especially in federal court where you need a unanimous verdict, that tends to pull any values down. When you have something like that happen. And again, we don't have complete feedback on the exact reasoning behind the verdict, but it was a plaintiff's verdict, and it was I think an absolute declaration that this product should not be on the market, and many of these products that Bard makes and Covidian makes should not be on the market anymore because they continue to hurt patients. So getting that design defect verdict in favor of the plaintiff was a big deal.
Yeah. Well, in the Milanese trial, and we talked about this, it involved many of the same expert witnesses as the first trial. So I guess the questions, is this common, and do you think this practice of using the same expert witnesses has a positive impact on the case outcome?
Well, so there were a couple of overlapping witnesses on the plaintiff's side. We had different surgeons, and especially on the case-specific front. I would say it's less common on case-specific components just because you have surgeons who are more familiar with certain products and also with the defects associated with those products. So we did have a different surgeon. But from a material standpoint, the polypropylene is a problem. And so you're going to we had Dr. Mays, for example, come and testify in both of those cases where this is a chronic inflammatory stimulus. This is a polymer that will degrade in the body and that will stiffen and that will cause chronic pain and excessive inflammation and all of the injuries that come with that. And so do you need another expert to say that same thing, when you have someone who puts it so beautifully? I don't think so. So from a general standpoint, I think having consistency in expert testimony is fine. And it's just really a matter of, from a case specific standpoint, which surgeons meet the criteria or have the experience that is needed for the various products. And let me just point out, I think that we talked about this. I probably talked a little bit too much last time about the different buckets and the mechanisms of failures. And so I, again, urge you to look at the last interview that we had for anybody who's interested in the mechanisms of failure. But we in Bard, what we did and what we have created is a trial package for each bucket. So the first trial was an ST product. That's the ST bucket of products. We have a beautiful package put together for that. The second trial was what's known as the EPTFE, or the permanent barrier. and that's the Ventralex. And Bard makes, I think it's over 8 products that have that problematic EPTFE barrier. And so we have a great trial package for that. Our next trial that's coming up is the third bucket, which is the bucket that is not does not have any of the barriers, but is the actual polymer and just the polymer itself. And I'm sure you're going to ask me about the third trial, so maybe this might be a good place.
Sure, go ahead.
So the third trial is actually set for October of 2023, and that is a plaintiff pick. It's a Perfix plug. The Perfix plug has been around since the 90s, and the Perfix plug is made of all polypropylene. There's no components like the ST or the EPTFE, and the reason for that is because it's an inguinal product. And so inguinal products are not placed up against the bowel. They don't need that same barrier to protect the body from the problematic underlying polypropylene. Again, as I said in our last interview, neither one of the barriers, they present their own problems. And so on those buckets of products, so I don't want my comment to suggest that either one of those barriers are effective, but they do have the barrier. The Perfix does not. The Perfix is a plug that actually looks like a badminton birdie. It's bizarre. I mean, you could literally, take a badminton birdie that you buy from Academy, and it looks identical almost to the Perfix. And then what they do is they just plug the hole in the inguinal canal, and then they put a little flat patch over that. So this trial, it has been moved. It was originally set for May of this year, 2023, and it's now set for October of 2023. And this plaintiff has had a significant amount of problems due to this Perfix plug.
Well, thanks for sharing that about the next. I was going to talk a little bit about the case involving Paul Trevino.
Okay.
And I know that's the first state court trial, that's been involved, the defective mesh implant. So, it wasn't an official Bellwether trial, but, does it lack any of the kind of quote official status that you would see as compared to an official Bellwether trial?
So first of all, great job to the state court trial team with that case. Got a great verdict, and that was actually the same. I believe it might have actually been the exact same year of implant as the Milanese case with the Ventralex product. So that's that EFE line of products. And as a reminder of the Bard product line, there was the original Kugel litigation, which has is what I would call in the EPTFE bucket of products. So prior to our 2 trials, the trial in Milanese and then the Trevino trial in state court, there were 2 data points for EPTFE. There was one that was a plaintiff's verdict, and that was a Kugel case, and there was a defense verdict, and that was also a Kugel case. And so what I think, to answer your question, absolutely the Trevino verdict, it absolutely helps because it's another positive data point for plaintiffs. Because there's nothing more annoying than hearing Bard brag about, well, there's only been 2 trials and one was a plaintiff and one was a defendant. And it's like, well, no, now we have 2 in a row. Ours obviously was in April, and then I believe 2 months later, the Rhode Island state court hit him with another verdict, 2 plaintiff verdicts in a row on a very problematic product. So absolutely, that's a positive data point, and just shows Bard that we can continue to try these cases and we can continue to win.
Yeah, positive data point, but I guess, why is this case, being a standalone case, such a big deal for the BardMDL?
Well, again, it's because it's products that are in the BardMDL. It is a message, frankly, to Bard's boardroom, which now is Becton Dickinson, which is we purchased CR Bard in 2017. That what the boardroom needs to realize is that we're going to continue to fight, and that we have had positive verdicts, and we're going to continue to have positive verdicts. And so it might make sense to come sit at the table.
What about tell us a little bit, and if you can speak to the Lone Pine motion that was filed last May.
I'm happy you asked about the Lone Pine motion that was filed last May. It was actually it was filed just so nicely on the Friday before Memorial Day weekend. When we frankly, it was a surprise. It was a very disappointing filing from the perspective of the PSC and the MDL. We were surprised and we were disappointed. And the filing essentially said that the cases that are being filed now are somehow weaker. Not true. And that there should be this very for those either who are just beginning practice in the mass tort arena or not lawyers. A Lone Pine motion asks for an extreme remedy, and it's named after a New Jersey case, Lone Pine, obviously the same name. And what it asks for is for a burden to be placed on a filing plaintiff that is quite extraordinary, essentially getting expert proof, etc., prior to even being able to file the case. And the judge pretty quickly actually denied that motion, and cited several cases that that essentially stood for the proposition that a Lone Pine order is an extraordinary order and is done when there is a settlement, typically global in nature, and it's essentially a door closing mechanism. In other words, it's a mechanism to kind of put a closure on litigation, and to be sort of a gatekeeper for future claims. But it's such an extreme remedy that is only given when the defendants have earned that remedy. And the judge did not find that had occurred here, because the defendants have made no meaningful progress towards resolution. And so it was denied. And we were very happy for that result.
Yeah, that sounds great. Settlement. Everybody wants to know about settlement. I know there's been some rumblings about the BardMDL reaching settlement prior to the court date. What are your thoughts on this?
So number one, I want to say that anybody who is reading tea leaves, predicting why the case got continued, our third Bellwether case got continued from May to October, should stop reading into anything. What happened there is that the plaintiff is continuing to have pain and has actually an upcoming procedure. And so the plaintiff's medical care in that case has not reached a point where essentially we're ready for trial.
Sure.
So that is the reason for that movement. We did oppose the movement, but frankly, I think that the judge, I just wanted to get to the courthouse and try this case because I'm so excited to try it. But given the fact that he has a groin exploration coming up, and we'll have depositions that will be, necessitated because of this surgery, expert report supplementation, etc. It was just going to be too tight, and so that's why that trial got moved. We also have an upcoming trial in January, the fourth Bellwether trial, and that is still there has not been an official setting, but the tentative plan is for that trial to take place in January, and that will be the fourth and final Bellwether trial of this MDL. Here's what I can tell you about settlement is that I think at the last interview, I might have been overly optimistic about the willingness and the approach of the defendant, and that here's what I will say. We are preparing to try the third and the fourth Bellwether cases, and I actually firmly believe that those cases will be tried, and that I think case counsel needs to be ready for potential remands, and that I think that's all I can really say about that.
Sure. Yeah, no, that is great insight. As far as global settlements go, do you think that will happen? Global settlements of the BardMDL in 2023?
I don't know that global is on the table at this point, Susan. I don't. And could it eventually be on the table? Maybe. Here's what I will say is that, I think when we talked back in 2021, we were at 13,000 cases, give or take. We're now at 18,000 cases, and it's going to continue to grow. And I just don't know if it's the sheer number that's just so difficult for this particular defendant to address in a global fashion. I don't know, and I'm not going to attempt to try to read any sort of motives or anything, or try to get into the mind of the Bard boardroom. But what I can say is that we will continue to file cases. We will continue to litigate these cases until there are fair values that are brought for our clients, because we feel very strongly about the strength of these cases. We feel very strongly about the trial package that we have put together for all of the buckets. So case counsel should not be concerned if there is a remand, because we do have trial packages.
Okay. Ethicon. I know you were associated with Ethicon lawsuit, and as of May 2022, the J&J Ethicon PhysioMesh lawsuits have been settled. I know there's many differences. What would you say the biggest difference between Ethicon and Bard lawsuits are?
I think that it simply boils down to the mentality of the defendant. I think that there's the level of pragmatism, and I do think that the fact that there's such a large number, and this is true for Covidian too, as I said in the beginning of this, that Bard and Covidian make up the largest market share, and with a significant number of products, I think that affects the mentality of the defendant and their willingness to settle, frankly, because it's a huge chunk of their business. And so, I don't necessarily know that I think it's as simple as just, it's a difference of personalities.
Mm-hmm. What about just the strategy going forward in this case? Can you share any insight on that?
Yeah. So, and when you say this case, let's talk about just hernia mesh, generally the strategy going forward. I will tell you that Bard and Covidian are my focus, and those are the, it's over 80% of the market share, Susan. Over 80% of the market share is still out there.
Yeah.
Still hurting people. And we're going to continue to litigate. And that's really where my focus is, continuing to build the story and to strengthen the story, and to continue to essentially refine our positions and our arguments. And with Bard, we're further along in the discovery process just by the nature and the history of that litigation. But Covidian, we're gonna put the same amount of effort that we put into Bard in building all of these stories. And the Covidian story, frankly, with the polyester polymer, it's a terrible, terrible polymer. It's highly inflammatory. And so we're going to put together great trial packages for Covidian as well. And that is an MDL that just got started, and we've got Bellwethers picked, and we're looking forward to, really building that case and trying those Bellwether cases. And this is in the District of Massachusetts, where Covidian is their hometown defendant. So the judge, arguably, I'm sure defendants will argue whether or not there's personal jurisdiction, but we think that there is personal jurisdiction in Boston, and there's no lexicon waiver needed. And this judge has indicated, Judge Saris, that she said she's ready for trials. And she says, my docket's not really crowded, and this district is actually not crowded at all. So we're ready to try these cases. And so to answer this is a long way of saying that the litigation strategy is to try these cases and to continue to show these defendants that we put together a great trial package, and that every single case that we take to them, that there is a significant risk that jury is going to give a verdict for the plaintiff.
Awesome. You pretty much answered all the questions that the attorneys are always asking me about hernia mesh. And I'd had a lot of questions lately, and I was like, we need to get Kelsey on again. One, just because we need an update. It's been a couple of years. And then two, don't ask me these questions. Let's ask Kelsey and hear it from her. So Kelsey, as always, it's such a pleasure. I really appreciate you taking time to spend the Friday afternoon connecting, talking all things hernia mesh, and just to be able to give our listeners updates and the insights about this litigation. And it's just great to hear that like you said, 80% of the market share is still out there. There's still cases to obtain and get worked up. And so thank you so much for your time.
And
can I
just leave with one thing? For litigants, case counsel out there, as well as the plaintiffs, I just want to stress that we are working our butts off on building these cases. And I think the sheer size of these defendants is, one of the reasons why it's taking the time that it's taking. And so I want to stress, I want to stress that people just ask for patience, because these cases are going to be successful. I firmly believe that. I really do. And I know that the clients are getting frustrated. I know that everybody is waiting for things to happen. We are working so hard to bring a great case against these defendants, and we will continue to go to trial until fair values are out there for these clients. So please, I just ask for patience, and I hope everybody realizes how much work we have put into this.
Yeah, absolutely. No, that's a great message. And we appreciate all the things that you're doing and your firm is doing in this litigation for sure. Thank you again for taking the time, and we will talk soon.
Thank you so much, Susan. It was such a pleasure.